Tomorrow, my lord.
What day after tomorrow? When did you file?
We have filed it on
Will come up as per list.
17/8/22.
Motion. For motion, it has not come up.
Yes, it should be motion.
It has not come up.
No,
Even-
it came on 2/11.
It has not
But
come
on
up.
that day I was busy in another court. In that manner, case was passed off.
Oh, was it a motion? It is a
Yeah,
motion case.
motion.
It has not been moved at all.
Not moved.
Day after tomorrow.
Obliged.
Yes.
Kindly pass over the meta for the day only, next. Some personal difficulty on my part.
Under prayer,
Part to convert.
ask one a matter stand at. Yes,
May I
Next.
please, your lordship?
yes,
I beg to mention item number 22, your lordship.
yes.
We are going to file affidavit in reply, your lordship. Kindly give us 2 weeks time.
You are for whom? For the
Petition-
petitioner.
Yes,
What is your name?
Elmar.
On the prayer of Miss Elmar, the matter stand adjourned. For to enable the petitioner to file reply affidavit.
May I please, my lord? My lord, mention for listing, my lord. Any date, my lord.
What
2019,
listing?
My lord, there is urgency, my lord. It was
What
last,
urgency?
last listed on 24/9/2000. No, lordship, 23/2020, my lord, last listed.
Huh?
Last listed.
Is it a motion or?
Motion.
What motion? When it was filed?
Earlier it was listed, my lord.
And then?
Interim also given, my lord.
And then?
LCR received, my lord. As per.
No, we'll come out. There's nothing, no urgency. We'll come out all those. Yes, next.
May I plead your lordship? Item 24 of the daily list. Matter may pass over for the day, may not.
On the prayer of Miss, what is your name?
And Hasina,
L
Hasina.
for the petitioner.
Yes,
Matter stands adjourned. Please, next.
obliged.
Daily list for motion item number 1.
My lord, present tell my lord, petitioner himself casted vote in the year 1971, my lord.
LCR is there, so we'll list for hearing.
Yes, my lord.
Since the records have been listed, the matter will list for hearing. Next.
A date may fix, my lord.
No.
Item number 2.
Obliged.
Barkat Ali.
May I please, your lordship? It's a contested matter, my lord. He has exhibited voters list of 1965 of his father and mother, 1970 of his father and mother, and subsequent voters list of 93, 97, 2005 of him, his wife and other.
Yes,
family members.
Verma.
Exactly.
We'll examine notice record interim. Yes, next.
Deeply impressed.
Item number 3.
May I please, your lordship?
Yes.
This is also a contested case, lordship. Here, she has exhibited voters list of her father and mother of 66, 71, and as 93, lordship, and she has examined the Ahura, lordship.
Yes, Verma. Notice record interim. Yes, next.
Item number 4.
Yes, anybody for Usharani? Who's for Usharani? Yes, Das.
Lordship, I take it after some time, lordship, it for registration,
Oh, registration.
yes, lordship. Maybe a timing for the.
Petitioner who is Mr. S. Das, Miss M. Das. For registration only.
Yeah, it was by order dated 21/9/2021, very recent order. lordship.
Oh, I see. Yes, what is your problem?
My lord, the petitioner was declared foreigner in the stream of 1966, 1971, my lord.
Mhm.
She was supposed to appear before the registrar, my lord, on within 30 days, but due to her illness, she could not appear, my lord.
Yes, Verma then.
Yes, some extension
Huh?
of time, some extension of time. may be
Okay, Hal,
granted.
Mr.
As Dash, my lord.
And a council for Pina also Miss Verma for the state, as well as others. सबका नाम लिखो. हाँ? The present petition has been filed seeking for extension of time for registering the registration herself. Under subsection 3 of section 6A of the Citizen Act 1955 rule, read with rule 19 of Citizen Act 2009, after she was declared to be a foreigner within the stream of
21/9/21.
Business stream of business stream of business stream of
66.
1/1/1962, 25/3/1971,
25/3/71.
which entitles a person which entitle a person so declared foreigner to be registered as provided under the aforesaid rules. It has been submitted though the opinion was rendered on 21/9/2021 and a petitioner was supposed to register herself with a competent authority. Because of illness, she could not register herself with a competent authority, registering authority. In connection with this, the petitioner has drawn attention to a number of documents to show that she was indeed suffering from sudden illness for which she was undergoing treatment. Ms. Verma, Learned Counsel for the Statement, also has submitted considering the consider fact that she was suffering. The authority will she will not have any objection if sudden time is granted, the time is extended to enable her to register herself. First of, we are also having gone through having heard the Learned Counsel for the parties, also having gone through the record, documents annexed in the petition are of the view that she may be, that a petition may be granted some more time to she may be granted extension of time to enable her to register herself with the competent foreigners regional registration officer at Borpeta as directed by the Learned Tribunal. Accordingly, the present petition is allowed by directing the extending the period of registration by another 1 month's time from today.
Another 30 days.
By another 30 days from today, in terms of the direction of the Learned FP in FP case number 253/2016, passed by the FT number 2 Borpeta. Disposal on French, huh? Precedents and disposal.
Item number 5.
Yes,
Please, your lordship. Lordship, the petitioner is here against order dated 12/2/2020, your lordship, passed by Foreigner Tribunal, Baksa, your lordship. The petitioner was also earlier been considered as not a foreigner, your lordship. In your lordship, FT case number 135 of 1987, your
call for the
lordship,
record.
page number 41.
Mr. Call for the record, notice record interim. Call for the record. Call for record in this number 1. The present FE is
Present FT is, your lordship,
page
at page number 92, annexure 9.
92. And earlier FP,
Earlier FT, your lordship, at page number 41.
both.
Your lordship, one more small prayer. There is also another FT, your lordship, wherein the petitioner's sister was also considered as not a foreigner, your lordship. That also may be called for your
Number 3,
SOP, cis tenses.
page number.
Your lordship, at page number 82. Page number 82 to 84.
So there are 3 FPs, 82 and number 1 is,
Number 1 is present.
Sister has deposed for the procedure or not, lordship.
anyway, we will see, we are just referring the
It will be
record.
examined, lordship.
Yes.
Item number 6.
Flag, your lordship.
My lord, apart from the merit of the case, my lord, we have raised question about the LBO report. LBO report does not show that the procedure was asked for in documents. And
Examine, lordship will call for the records.
Okay, notice record interim.
deep level.
Item number 7.
May I please, your lordship? In this case, already earlier there was a proceeding and the petitioner was declared as a foreigner. And he has contested that matter, and that is WPC number 2636 of 2018. I have annexed the copy of the writ petition as an annexure.
It is pending before this court.
Yes, Lordship, and I'm on interim in that case. And subsequent a notice has been received on 35, dated 35.
If a writ petition
2022.
pending, na, this issue notice, call for records. This along with WPC number
2636, 2018.
2636.
36, 2018. Lord.
As it has been stated that the petitioner have been already also granted bail, huh?
Yes,
In that
Lordship.
case, huh?
Page 80, Lordship, interim order,
Bail so accordingly.
order dated.
Similar
26.
order also passed in this petition.
This only notice is issued, so I am telling the notice.
As a notice in issue.
Yes,
Okay, let me challenge, issue notice, number 4, we call for the records.
Deeply.
List along with WPC number 2636/18.
deeply.
There's no need for any interim order. Yes.
Item number 8.
May it please the lordship. My lord, page 60 is the interim order. Post, page 60 it starts.
60.
60, my lord, and post 71 declared foreigner. My lord, exhibits was not, or evidences were not appreciated in pursuance to your lordship judgment of 22(3) JLR page 64. Like, my lord, exhibits like age and in Gambura certificate, Jamabandi certificates. Those were not
Verma.
appreciated.
Examine Lordship.
Notice record interim.
Okay.
Item number 9.
My lord, petitioner's father's name, my lord, appeared in the NRC of 1951 as well as voter list of 1970, my lord, page number 12 and 14. And my lord, her name, my lord, Gaubra is examined, my lord, who issued the certificate regarding link, my lord.
Notice record interim.
Item number 10.
In this matter, lordship, the LVO report, lordship, that is in my favor, in spite of that, lordship proceeding was going.
Okay.
Examine at this.
Notice record interim.
Item number 11.
Yeah, please, my lord, in this case, my lord, apart from the exhibiting the documents, my lord, 3 witnesses were examined, including the mother and headmaster of the school where say.
Verma.
Examine Lordship.
Notice record interim, yes.
Item number 12.
May it please the Lordships. Lordship, it's a contested matter. Order is at page number 41. Lordship, in this case, DW2 is the elder brother who had casted vote along with the father and mother, and father and mother had casted vote in the year 1966, Lordship. 1970.
So the brother was examined.
Yes, Lordship, as DW2.
Cross examination
And done, Lordship.
done.
And DW3 is the younger brother and DW4 is the Lat Mandal.
Okay, notice record interim.
Trouble.
Item number 13.
Yeah, it is your lordship. My lord, it's a contested matter and petitioner has exhibited voters list of 1966, 1970, 97, 21 and Jamabandi, where he has inherited the property of his father lordship. And elder brother has adduced evidence Gambura of 2 villages. There is a
Yes, Verma.
shifting. Examine lordship.
Notice record interim.
Deeply obliged.
Item number 14.
The petitioner's grandfather was issued NRC and her father's name also, my lord, appears there, my lord. And my lord, the petitioner herself was issued the recent NRC, my lord, whose name appears in the sponsor certificate as well as PAN card, along with his father, her father, my lord.
Notice record interim.
Supplementary list. Item number 26 to 31 for motion.
Lordship, this matter may be passed over for the time being. Mr. Fine will come.
Jonglu.
The transfer matters.
Okay, transfer. But you have submitted your argument.
My lord, we have
Only Pine is.
Pine is to submit.
Okay. Okay, we'll wait. Yes, next.
Item number 32, supplementary list for motion.
But in this matter, my lord, the extension of time for registration, my lord. The case was, my lord, initiated here mother and sons and daughter, my lord. And all the step was taken by my father, my lord. He was expert 94, my lord. And nobody knows they got the proceeding, my lord. So last occasion,
In this matter, records are there on the last date. We had gone through it. I have made a note also. Lordship may fix this up for hearing. There are a lot of discrepancies in the
my lord,
LC
the
award.
order itself, they are
Yeah,
named
order.
registered.
Lordship may look at the earlier order passed on 21/10/2022. Lordship. Order has been passed. May I read it, Lordship?
And father was.
Perusal of the
registered
record, we
1990.
have seen that
Nobody was
after the death
known,
of her husband on
All this-
28/6/1994, the present petitioner appeared before the tribunal on 12/9/1994 and 12/11/1994, and also filed a list of documents which clearly reflects that she was aware of the entire proceeding, and in the writ petition, they have suppressed all the facts, Lordship. They have not come with clean hands saying that they were completely ignorant of the facts.
In written statement.
And from the written statement filed on 21/1991 by Abdul Rashid, husband of the petitioner, and the father of the petitioners, numbers 2 to
Okay,
7.
list after 2 weeks, huh? On the prayer.
Hearing, Lordship.
We will hear whatever.
Yes, Lord.
My lord, kindly,
Verma, on the prayer of Miss Burma, the matter will list after 2 weeks. Yes, next.
Item number 33.
my lord, kindly date other is it.
I read the book.
3011 30.
No, no. Lordship, not 30/11, first week of December. I may not be around at that time.
512.
No, please, Lordship. Now, his petitioner once declared final also.
Hmm?
Petitioner once declared final also, but then thereafter, they approached this honorable court. Honorable court remand back the, back, citing this, that the petitioner father examined by the tribunal also. And other two witnesses, the London Tribunal, the earlier opinion discussed, nothing discussed at all. In the second opinion, he discussed, only stated everything, no reason is there. The fifth case for remand,
Lordship
but
will examine the matter. If the tribunal is not examined, passing opinions, detailed reasoning.
Then let the, we'll remand the matter to the tribunal, give a detailed reason.
It's already been done once.
No, no, but then let us see the reason, let us see the intent.
Let us see both the opinions
there's
together.
High Court order, Lordship, page
No,
6.
forget High Court, last order.
Last order, Lordship. Lordship, it starts on page 85, Lordship.
Order. Reference has been transferred, issued. Proceeding submitted evidence.
No, whisper about the High Court order also.
Yeah, no, doesn't matter. High Court order need not be mentioned.
Okay.
There is no harm with that. Question is whether the tribunal properly applied his mind.
Lots of-
Posted as follows. Say to younger. While going through entire conclusion, then the evidence had not endorsed. We'll hear it, we'll list the matter for hearing. Why records have received?
No, Lordship,
Sir,
it's a
the
list
motion,
of
motion.
Oh,
to read.
motions we will call for examination.
Yes,
Okay,
Lordship.
okay, notice record entering me. Okay.
Deeply applied.
Item number 34.
Right. My lord, the petitioner approached before this honorable court, my lord, setting aside the expiry order of the tribunal, that was set aside. And my lord, the secondary petition is filed, my lord, before this honorable court. Her father's name appeared in the voter list of 1966, my lord. Page number 31, and her sister is examined, my lord. Own sister examined, my lord.
Yes, Verma.
Examine.
Notice record entering.
Obliged.
Daily list for admission. Item number 15.
May I plead your lordship? Lordship, in this case, my lord, respondent number 527 are Bangladeshi nations, my lord. I have annexed some of
My
documents.
brief is missing, government brief is missing, petitioner's brief is missing. This matter may be listed some other day, lordship.
But she remembers everything.
She came and told me and we also all looked. We couldn't
Looked.
find it, lordship.
Okay. She remembered without any document, she remembered everything. Huh? Okay, so what to do?
See, let's start with 3 weeks. We'll also try to find it.
2016 matter.
Yes, lordship. I will reconstruct our file.
Okay. State of Assam.
And in this matter, I do not know if notice has been issued or if records have been called for or not.
Earlier, nobody appeared. What is your name?
El Wajida, my lord.
El Wajida. You are a legal aid counsel or what? No. The original counsel.
My
Huh?
lord.
I didn't get time to go through the record.
Miss El Wajida. Or Miss El counsel. Also Miss Verma. Land counsel for both the parties. Submit that. They would require, as the files are missing, they would like to reconstruct the file. But in this case, considering the above, I am of the opinion that the opposite party, Akhil Chandra Dev, is not a foreigner. Who has filed this? Akhil Chandra Dev, okay. And what is the impugn order? Asim Dev.
Ashim Kumar Dev, your lordship.
Amrish Chandra Dev. Amrish also not a foreigner. Then who has been declared a foreigner?
They have manipulated some of the documents, my lord, voter list and some other.
Who has manipulated?
Respondent number 527, my lord.
No, who is this Asim? What does he want?
My lord, he was a.
Legal action against private respondent 5 forgery. Huh? Who is manipulated? Legal action 567. Akhil Chandra. Asim Chandra. Who is this Asim Chandra? Who is this Asim Chandra?
He's my lord,
Huh?
social worker, my lord.
Lordship, I may be allowed to reconstruct my file with the court's file, lordship, and lordship will fix it up. I remember I did appear in this matter once, lordship.
You are public spirited. So you also.
It's like, I think this gentleman, the petitioner has filed against some other people that they are foreigners. Yes, yeah, I remember, lordship, this matter that we did appear once.
According to them, they are foreigner, they are manipulated people, therefore.
And in one of the others, this court had even asked what was his interest in declaring other people foreigners when.
But what is the, we don't understand, what is the locus of this person, gentleman? The government can verify, if the government can always, if the government feels that,
Yes.
I don't know, why should we keep this matter pending?
It
It's
is not
nothing to do
morally
with,
policing. I can't say somebody is a foreigner, lordship.
it is for the government to decide.
Authorities are there to verify, inquire, lordship.
That is, we'll say that it is for the government, if the government, they
Lordship,
can
I
make
dismiss-
necessary
I
verification, the
dismiss this
government feels that,
petition,
yes,
Lordship.
certainly, if somebody on the basis of forced document claims Indian national, and as far as forgery concerned, it vitiates the proceeding void ab initio,
Yes,
right from the beginning. There is no law of limitation. If you detect forgery now,
Yes, Lord.
even for an opinion which was rendered 30 years ago, you can get it set aside. Because this is, therefore, we don't know why should we keep this. And Miss Wajida Lana counsel for the petitioner, also Miss Verma for the state. The present petition has been filed alleging, by the present petitioner alleging that the private respondent number 4, 5, 6 and 7 had obtained certain favorable order from the foreigners tribunal declaring them to be Indian citizens on the basis of certain forged documents, certain manipulated documents. Was the notice being issued earlier? In this petition, the state respondents have also filed an affidavit. And in fact, the principal secretary to the government of Assam, Home and Political Department, as well as additional Director General of Police, had also appeared before the court, explaining the position . Stating that there is a state level screening committee which scrutinizes orders passed by the foreigners tribunal, declaring proceedings as not foreigners. Full stop. If that is so, we have the view that it will be more appropriate for the state authorities to examine the opinions rendered by the foreign tribunal declaring the respondent of 5, 6 and 7 to be Indian, not foreigners, and take necessary remedial action, including challenge the opinion of the same. If it is found that the said proceedings had obtained the opinions, a favorable opinion on the basis of manipulated documents. With the above observation, the present petition is disposed.
Oblige, your lordship.
Item number 16.
May I please, lordship?
Yes.
In this case, my lord, elder sister's case already.
What is this matter listed for what? Admission?
Admission, my lord.
We'll admit.
Yeah,
Records have been received, the matter admitted for hearing.
Item number 17.
Oblige.
What is this? Admission? R. Hussain. Records, since the records have been received, the matter be listed for hearing.
Item number 18.
18 also, yes.
For admission, madam.
Since the records have been received, the matter can be listed for hearing.
Item number 19.
Lordship, there are only two things that I wanted to point it out, your lordship. The impugn order is on page 29, your lordship.
Listed for what? Today for what purpose?
Admission, your lordship.
And we'll admit. Since the records have been received, the matter be listed for hearing.
Item number 20.
Anybody? Since the records have been received, the matter be listed for hearing.
Item number 21.
Yes, records have been received.
My lord, one thing I want. My lord, in this case, my lord, earlier he was declared Indian by
21.
the same tribunal.
So, is it a case of res judicata, you mean?
Res judicata, my lord.
If it is res judicata, let us see.
My lord.
What is the earlier opinion?
Earlier opinion is page, my lord,
I think was missing in this one.
page 25, my lord. Last page, my lord. Paragraph number 4. His name is reflected, my lord. Page 25, it is the earlier question.
Idris Ali and others.
Idris Ali, my lord.
Who is Idris Ali?
Better. Idris Ali is better, my lord. Then
Idris Ali, Sufia Khatun.
And Abdul Jabbar. Abdul Jabbar is the petitioner, my lord.
Of village Dokhin Senimari.
Lahori Ghat.
Lahori Ghat.
This is
And
the
all have been declared Indians.
Indian, my lord. This is the
And
first
next,
proceeding.
and the second
Second proceeding is, my lord, lordship may kindly see
Abdul
page
Jabbar.
60, annexure 8. And my lord,
Whether the first opinion was placed before the tribunal or not, lord.
Did you rely on that? No.
my lord,
Did you mention before the tribunal
In the
that
second
yes, there was an opinion which
I don't know, my lord. I don't know, my lord.
if you don't know, then
Than that, how will the tribunal know he is the same person? In the first opinion.
But,
and
my
in
lord,
late- and
but, my
later
lord,
now.
the certified copy of the said order has been exhibited there.
oh,
Exhibit number same in the 7. Lordship may kindly see page 62, my lord.
7.
7, my lord. The certified copy of the judgment and order passed by the member Iman.
Document saying Sariba copy of the so and so. Wherever it is, the judgment is deferred by me. On going to judgment, it is found while passing a judgment, there was no proper option. That cannot be done.
Lordship will hear the matter, lordship, because we do not know if he is the same Abdul Jabbar at that point. in
Correct.
time.
That is correct. But the learned tribunal says that I do not agree with that judgment. That the tribunal cannot do that.
She could have said, or he could have said that.
I agree with it. So the learned tribunal cannot say that.
Or a reasoning may have.
List day after tomorrow, have a look. Report, huh? Since you don't have the record, have a look, huh?
I'll do that.
Day after tomorrow. List day after tomorrow.
Wednesday.
In 11.
All right, my lord.
Item number 23.
Yes. Records have been received, will for hearing. Notice since the records have been received, let them be. Yes.
Supplementary list for admission, item 35 and 36.
Ravindra Mandal,
May I please, your lordship?
records have been received.
Record received, my lord, what happened? One is in res judicata, my lord.
Which one is Rejurigita?
Item 36, my lord, Hiralal Mandal. 7952.
And who is Ravindra Mandal?
Ravindra Mandal is the son of Hiralal Mandal.
Ravindra Mandal is son of Hiral Mandal.
Yes, ma'am.
And you said Hiral Mandal has been declared Indian.
Yes, madam.
Why is it? What is the earlier opinion?
Lordship, page 43, my lord.
Page 43,
Yes, madam.
Board Peta, Tribunal 3. Hiral Mandal, the reference and the censor. But as per direction, he along with his parents are citizen of India. OP in his similar father state, his father is late Okali Mandal, migrated India before him for late Okali Mandal. And let us see in the present proceeding, what did you say?
Page 47, my lord.
On Vision Ananta Mandal, who is Ananta Mandal?
Ananta Mandal is another son of Hiralal Mandal. 150 is also
According dates
pending.
were fiction. The dates were allowed. Referendum made against Hirananda. You didn't file any WS. Written statement you didn't file.
No, my lord.
Then if you don't file written statement, how the tribunal will know that you are the.
So I may be allowed to
You go,
submit.
yes, we'll remand it. Let him file it up. Since written statement has not been filed.
No, my lord, one thing your lordship may consider,
Yes.
the tribunal has given enough opportunity. It is not the case that he didn't know, my lord. It, he
Oh,
appeared in the
because
proceeding.
thing is that Mr. Payeng, if somebody has been already declared in India, will it by default become a foreigner?
My lord, it is.
The question is statistics. See, if a person if he is not declared a foreigner, there's another thing that he was not bothered. There's another issue. But he's been already declared Indian.
My lord, if he's the same person,
That's
why
why
he did not disclose that in the very first?
No, that is what
Several times for filing WS.
during the
But he
dates
should
were
not
fixed
say
on sense.
that I
And
have
at
been
that
already
time,
declared
the law was still different. Maybe that because that law was not applicable.
My lord,
There may have been
the
also.
same law, my lord.
No,
was
same law, it
law.
was not there. Till Abdul Qudus, it was held.
Even, my lord, this issue was not there prior to 2018, my lord.
Anyway, we are okay.
Only thing is that, my lord,
We have heard it, we have understood you.
No, my
That
lord,
is your plea.
And first of all, in case of Hirolal, my lord, your lordship will see, Hirolal was declared foreigner, Indian, as per him. The address is different. Address is different, my lord. But subsequently, he received the notice. He did not, he appeared there. He filed application that I will file WS. He took several times. Then now he is coming here that I was declared as a citizen by this opinion. So I am the same person. This should have been taken in the very first day itself. No, I have been declared because it is his personal knowledge. Nobody can say except him that if he is a declared Indian, my lord, it should be in the very first day itself he could say. If I have been declared for Indian, my lord, I'll go first day itself. I'll say I have been declared Indian by this tribunal. So why are you proceeding me against me?
In that even my submission.
After, my lord, taking, my lord, 13, 6, 18, 7, 7, 18, 23, 7, 18, 13, 8, 18, 6, 9, 18, 5, 10, 18, 5, 11, 18, 4, 12, 18. After 1, 2, 3, 4, 5, 6, 7, 8 days, my lord, the petition level, the application, my lord, tribunal has passed the expert order. Now, after, my lord, after 2018, my lord, now he is claiming that he is the same, against him, there is a declaration that he is an Indian man. So the entire, my lord, situation, we have to go by the facts and circumstances of the case, man. The situation, my lord, doesn't say so that he is the same person. It is not that, my lord, he didn't know that there is a case pending.
In the subsequent proceeding was against whom?
Against Hirolal Mandal. Hirolal Mandal.
Kiran Mondal and others, one
And
four
others.
six nine, 1469. 1469.
The
And
impugn
1491. 1491.
One four nine one is again, my lord, is this is against Rabindra Mandal. 1491 is against Rabindra Mandal.
Hard Mr.
S. Alim.
And counsel for the hard Mr. Final and a counsel for the state. सबका नाम लिखो. In this petition, the petitioner challenged the ex parte order dated
512.
5/12/18, by which the how many petitioners?
My lord, what happened? There are 3 petitioners, but by an earlier order passed by this honorable court,
Others have
dated
been struck out.
19-9, my lord, the others are strike out, my lord.
The petitioner had challenged challenged by which the petitioner was declared to be a foreigner. Perusal of the impugn order 5/12/2018 shows that after notice was served upon the proceeding, the tribunal fixed a number of dates for filing of written statement, which however could not be filed. Accordingly, learned tribunal held that since the proceedings did not file the written statement even after giving sufficient opportunities, the matter was proceeded ex parte. And what is the reason why you cannot appear what you have given in the petition?
My lord, before coming to that, my lord, may I take your lordship to the inquiry, my lord? The inquiry.
Oh, we are asking one thing, please don't go with that.
My lord, due to communication gap with the advocate, my lord, engaged counsel, my lord.
Learned counsel for the petitioner is that the petition, it is not a case that the petitioners were not willing to contest a claim before the learned were not willing to contest a claim before the foreigners tribunal, but because of communication gap with the petitioner's counsel, the petitioner could not file the written statement as mentioned in para number. Why is the para number? Why have you stated?
Paragraph 15 and 16, my lord. Sorry, my lord, paragraph 18, my lord.
As mentioned para 18, wherein it has been specifically mentioned that that the engaged counsel of the petitioner withdrew the wakalanama without informing the petitioner. Next para. Petitioner otherwise submits that there was earlier a proceeding initiated before the foreigners tribunal. Page number
43, my lord.
The foreigners tribunal 3 Borpeta in FT case number FT third tribunal case number 126 within bracket Roman 3/2009, wherein by an opinion dated 1/10/2009, the petitioner Hiralal Mandal had been declared to be Indian. Stop. And it has been submitted at because of this inability. According it has been submitted since the petitioner was declared Indian by an earlier opinion, the subsequent proceeding would not lie. However, because the petitioner could not file a written statement and a matter was proceeded ex parte by the learned foreigner under the circumstances mentioned above, the petitioner has been declared to be foreigner, thus causing a serious prejudice as regards his citizenship. Stop. Next para. Mr. Payang, however, on the other hand, submits that the petitioner has to be blamed for the situation he has been placed now. In which case, the records would indicate that sufficient opportunity had been given to the petitioner to appear for the tribunal. However, the petitioner failed to appear for the tribunal, and as such, and as a the tribunal could not be faulted for rendering the ex parte order. So we have heard the Lana counsel for the party also perused the records. We have examined the perused the records which have been requisitioned. There is indeed a opinion rendered by the Foreigners Tribunal 3 Borpeta in FT case number 126 Remand 3 up to 19, wherein the Learned Tribunal had passed an opinion 1/10/2009 and 9 that one Hiralal Mandal, who was born and brought up at village Rivita, PS Satharwari, was declared to be a foreign to be an Indian by citizen by birth. Full stop. In the subsequent proceeding before the tribunal, same tribunal, but in a different proceeding, FT case number 14693 of 2013. In the tribunal wide opinion dated 5/12/2018 had declared the said Hiralal to be a foreigner as he failed to file the written statement. Full stop. As regards the applicability of res judicata, it is now well settled in view of the decision of the Honorable Supreme Court in Abdul Qudus versus so-and-so in India, 2019, volume 4, so-and-so, which have been followed by this court from time to time. And if it is ultimately found that the present petitioner is the same person who was declared to be Indian by an earlier opinion rendered on 1/10/2009 in FT case number 136 of 2019, the subsequent proceeding would not lie, and the petitioner would be entitled to be declared to be Indian. However, this is a question of fact which is required to be examined by the tribunal in as much as no such records were produced before the tribunal. The contention of the learned Mr. Payang, learned counsel for the state, that it cannot be also proved that the proceedings are different persons, staying in different locations, is also required to be examined by the tribunal.
One more thing, by the
Yes.
question of res judicata cannot be brought into later. It should be brought in the first day itself, in the first proceeding itself, not in the.
And also it has been submitted that the question, the issue of res judicata has to be brought at the first instance, not at the lateral stage as it has happened in the present case. However, as mentioned, we have noted his submission, but since the written statement could not be filed by the petitioner in the subsequent FT case number 14669 of within Remand 3 of 2013, it can be said that the petitioner did not raise the issue of res judicata. Be as it may, we are satisfied on the basis of the records that the petitioner would be entitled to be given another opportunity to appear before the Foreigners Tribunal 3 Borpeta in FT case number 1469 of 2013 and file his written statement taking all the plea, including the plea of res judicata, before the learned tribunal, and the learned tribunal, after considering the same in accordance with law, and after hearing the the petitioner, the proceeding, and the evidence that may be adduced, and considering the evidence that may be adduced by the proceeding, will consider the issues and pass in a fresh opinion. Accordingly, the present petition is allowed by setting aside the ex parte order at 5/12/2018 passed by the FT page 47. Petitioner will appear for the FT within a period of 1 month from today. So, till such proceeding, during the pendence of the proceeding, the petitioner will be allowed to remain on bail. However, he will appear for the SP Borpeta, 5,000 schedule, all other conditions also. Let the records, petitioner according to disposal, let the records be remitted forthwith. This is item number
36, madam.
36. Then what happened to Robindra Mondal?
This is also
Son.
expertise matter.
This is also ex parte order.
Yes. Only before going, my lord, I want to rely this judgment of this honorable court.
Yes, sir. I will Liko next.
My lord, I'm not going
Ah.
anymore, my lord. Your lordship may
No,
kindly-
we will record it. We will record.
Page 16, para 16, my lord.
Yes, we will do that. We will do that.
Para 16 of.
Isme Robindra, the present petition has been filed by one Robindra Mondal, challenging the ex parte order dated
21/11/18.
21.
21/11/2018.
What is it?
Test 50, madam.
21/11, by which he has been declared to be a foreigner. It is the case of the petitioner that he is not a foreigner, but the son of one
Hiralal Mondal.
Hiralal Mondal, who was declared to be an Indian by the Foreigners Tribunal in FT 3, by Foreigners Tribunal 3 in Borpeta, in FT 3rd Tribunal case number 126 Roman 3 of 2009, by the opinion dated 1/10/2009. Unfortunately, the petitioner could not file his written statement in the before the learned tribunal.
Advocate and withdrawn the Okalatama.
As the advocate had withdrawn the Wakana without informing him, and as such, the matter was proceeded ex parte by the learned tribunal and declared the petitioner to be a foreigner. It has been submitted that if the petitioner could file the written statement and furnish all the relevant documents, including the fact that his father Hiralal Mondal was declared Indian, the tribunal would not have declared a petitioner to be a foreigner by the impugn order dated 21/11/2018. Full stop. In this regard, Mr. Payam has submitted that the inability, relying on a decision of the High Court, so and so, 2016, that if the proceeding does not appear before the tribunal and file her written statement, in spite of giving repeated opportunity to do so, the same does not warrant interference by this court. Full stop. While there cannot be any dispute about such a proposition of law in the present case, what is the distinguishing fact is that the petitioner's lawyer had withdrawn his wakalanama without informing, and as such, we have the view that the proceedings ought not be made to suffer because of the fault on the part of the engaged counsel. Full stop. Next para. Since we have allowed the writ petition WPC number 7952 of 2019 filed by the said Hiralal Mondal, who the petitioner Rabindranath Mondal claims to his father, we allow this petition and remand the matter to the learned foreigner for fresh reconsideration. We also allow this petition by setting aside the ex parte order dated ex parte order dated 21/11/2000 pass in so and so page 50. And the petitioner will appear before the tribunal, tribunal, and the matter is remanded for fresh reconsideration, for which the petitioner will appear before the tribunal within 1 month from today and file a written statement. And the learned tribunal, after hearing the petitioner and considering the evidence that may be adduced by the petitioner, will pass a fresh opinion as regards citizenship of the petitioner. The petitioner also will be at liberty to take the plea of res judicata on the basis of earlier opinion rendered by the learned F Foreigners Tribunal 3 Borpeta in FT, third tribunal case number 126 Roman 3 of 2009, dated 1/10/2009.
That case, my lord, he was notified.
But he may be allowed to rely on
That
that.
can be relied, but the res judicata issue will not come in that case.
Because his father.
My lord, that has to be proved by a
Correct.
separate.
Therefore,
my
he
lord.
can take the plea. He can raise the
He can
issue.
take the plea of my lord, that he can take that evidence, but he
Hmm.
cannot say that it is res judicata. Because it will be different party. my lord.
Petitioner may be allowed to take the plea that he, being the son of Hiralal Mondol, is Indian by birth. It may be mentioned that this court had allowed the Hiralal Mondol to take the plea of res judicata, and which may be allowed to, which may be relied upon by the present petitioner in this case also.
Only one thing, your lord, factual aspect.
Yes.
When did the my lord, advocate withdraw the my lord Bakalan? In the last thing. It is not the negligence, it is the negligence on the part of the my lord petition. He didn't come for almost 7 days, then only the advocate withdrawn the Bakalan. So always blaming the advocate will not do, my lord. This is not a my lord, this is a game, my lord, where they are playing hide and seek. They are sometimes blame in all the cases, my lord, they're blaming the advocates who are performing their duties well, my lord. But as they are not interested to come to court or tribunal, they are saying, my lord, in all dates, my lord, the advocate is taking steps. It is the petitioner who is not coming. So this kind of, my lord, this were, my lord, in numbers of cases your lordship will find, in all they will take the same step. Same, the advocates have not, there is a miscommunication on the part of the advocate. It is their duty, they have a case, my lord, it is their duty to, my lord, consult with the advocate. And the advocates may be met party, then it will be clear, my lord. Only blaming the advocates, my lord, even we are advocates, my lord, my lord, we feel sorry for that.
Next.
Obliged, my lord.
Left over item 26 to 31.
Yes, Mr. Pai.
My lord, before going to all other matters, my lord, I want to rely the honorable court's judgment in WPC 2780/2019. That is, sorry for this number.
You want to rely on? Sorry,
Yes,
Islam.
Sariful Islam. My lord, this is the latest judgment, my lord, of this honorable court. Wherein, my lord, the old issues, all the facts, all the particular this issue was dealt with, my lord. My lord, may kindly see from para 5 itself. Para 5 of the judgment, my lord.
Yes.
Under the citizenship rule 2009, this is my lord, citizenship, this 2009 rule is only for the purpose of registration of the mallet foreigner. For the registration, this is not the whole mallet. 2009 framed exercise of powers conferred by the section 18 of the Act 1955, part 4 thereof contains rule 19 and 22, providing for citizenship in India for person covered under Assam Code. For any reference, the same is here. On the registration, my lord may kindly say registering authority. For the purpose of subsection 3 of section 6A, the central government may, for the purpose of subsection 3, section 6A, appointed officer not below the rank of additional district magistrate as the registrating authority for every district of the Assam. An application for registration under subsection 3, section 6A shall be made by the person to the registering authority for the district in which such person is ordinarily a resident within a period of 30 days from the date of receipt of the order of the foreigners tribunal declaring such person. This thing has to be recorded, my lord. My lord, your lordship will find yesterday, last occasion, one of my friends submits that the my lord jurisdiction, my lord, for the time being 22 minutes, 22 of this, my lord, 21 of say next page, my lord, page 20, next page 22, my lord, 21, my lord, jurisdiction. His submission was that the tribunal, my lord, the language of 21 is the tribunal constituted under the Foreigners Tribunal Order 1964, having jurisdiction over a district or part of the state of Assam, shall have jurisdiction to decide reference received from the registering authority of the district or part thereof in relation to reference made under subsection 3 of the 6A. So the reference, my lord, by registering authority who referred the matter, that the particular registering authority who referred the matter, he has to decide, my lord, that reference has to be decided by that tribunal. And his submission is that he must be an ordinary resident of that area where he makes the application. It is not the permanent resident. It's clear, my lord. Language, my lord, language of 19.2. It is clear. An application for registration under subsection 3 of 6A shall be made from so-and-so in this form so-and-so by person to the registering authority for the district in which such person is ordinarily a resident within a period of 30 days from the date of receipt of the. My lord, the person where he has been detected or where he has been declared foreigner, there he has to be. It is not that, my lord, here the question, my lord, I'm coming to those aspects, my lord. Only thing, my lord, all these things were, my lord, discussed. Thereafter, my lord, the first point is, my lord, it is not that he must be, for registering, it is not necessary that he must be a resident, permanent resident of a particular place. It is only necessary that he is an ordinary resident for 30 days in that place. That is to do. 2009 Rule 6. Para 6 is the Foreigners Tribunal Order 1964 was enacted by the central government in exercise of the powers conferred by Section 3 of the Act 1946. Para 2 of the 1964 order provides for the constitution of Foreigners Tribunal. It provides that central government may by order refer the question as to whether a person is or is not a foreigner within the meaning of Act 1946 to the tribunal for its opinion. Thus, by virtue of provisions of Para 2 of the 1964 order, read with 21 of rules of 2009, it decides reference received from the registering authority of the district by rendering opinion as to whether the person is or is not a foreigner within the meaning of the Act 1946. And this matter registering authority, who is that registering authority? Where the person or proceeding resides ordinarily for 30 days. In this regard, notice had to be the notification dated 19/4/1958 was issued by the Government of India and Ministry of Home Affairs in exercise of power under clause 1 of the Article 258 of the Constitution of India, whereby the President, with the consent of the state government concerned, entrusted the government of each of the states mentioned here therein, including the state of Assam, the functions of the central government in making orders of the nature specified in Section 3 of the Act 1946, Another notification by the same authority and in exercise of the same powers was issued on 17/2/1976, entrusting the Superintendent of Police and Deputy Commissioner in charge of police under the government of Assam, the functions of the central government in the making orders of the nature specified in section 3 of the Act within their respective jurisdiction, subject to the conditions mentioned therein, which include the condition that exercise of such function would be in respect of the nationals of Bangladesh. Further, while exercising such functions, the Superintendent of Police and Deputy Commissioner in charge would comply with such general or special direction as the government of Assam or the central government may issue from time to time. Thus, by the aforesaid notification dated 19/4/1958 and 17/2/1976, these are the two notifications, my lord, on the basis of which the state government has got the power to make references, my lord. The Superintendent of Police and Deputy Commissioner in charge police have been delegated the power to make reference to the Foreigners Tribunal within their jurisdiction under para 2 of the 1964 order to seek opinion as to whether the proceed is foreigner or not within the meaning of Act 1946. Whereupon the tribunal is required to exercise jurisdiction having regard to the provision under Rule 21 of the Rule 2009. With regard to the issue relating to assumption of jurisdiction of tribunal in answering reference made by the jurisdictional superintendent of police, the applicable law in this regard laid down by the Supreme Court in getting of decision made by so-and-so. It has been held that jurisdiction fact is a fact which must exist before a court, tribunal, or authority assumes jurisdiction over a particular matter. It is the fact upon which an administrative agency power to act depends. If the jurisdictional fact doesn't exist, a court, tribunal, or authority cannot act. My lord, posing here for a moment, my lord, what my submission is that these are the cases, my lord, registered by the police. My lord, a person who comes from some places, wherever from, my lord, he may come from Bangladesh, he may come from, my lord, any part of the world. First of all, there is a doubt. On the doubt, he is detected, my lord, by some police station. Suppose he has been detained somewhere found in the, my lord, Jorhat. On the basis of his suspected. As soon as he suspected, the police asked him, make some inquiry, my lord. Do you have any documents and etc.? My lord, how the case is registered? I'm explaining that. Do you have any documents or etc.? If he fails to produce something, there the case register on that particular place itself. He may say that he is ordinary resident of Jorhat, but he is permanent resident of Delhi, or he is a permanent resident of Calcutta, or he is a permanent resident of Dhuburi, or he is a permanent resident of Guwahati. But when he was detected first, he was in that particular jurisdiction of that police station. Suppose he was detected in Jorhat, so his case is registered there. Now, once the case is registered, it is referred to the SP concerned after making an inquiry. Whatever his statement he is given, the proceeding gives, that is recorded in the statement. In the recording, he may say, I'm a permanent resident of Dhuburi. Or he may say, I'm a permanent resident of Calcutta. Or I'm a permanent resident of Delhi. Does it mean, the authority who has doubted him has to run after him to allow him to prove that he is not a citizen of India or he is not a foreigner? Well, it is the burden of the petitioner, it is the burden of the proceeding to prove that he is a citizen of India and permanent resident of, by virtue of residence of India, or by virtue of his birth. The very fact here is, their very first duty is to prove that he is a resident of India. The first question is doubtful, whether he is a resident of India or not. But now he is saying, I'm a permanent, in the statement he is saying, I'm a permanent resident of Dhuburi, or I'm a permanent resident of Calcutta, so matter may be transferred to that. That means we have admitted that he is a permanent resident of that place. For the entire fact, that means before trial we have accepted that he is a resident of India. That has to, it is their first duty to prove that he is a resident of India and he is permanent resident of that place. That has to be proved in the tribunal. That is the fact which is to be proved by the proceeding. Before proving, they're coming before this honorable court saying that, no, I'm a resident of permanent resident of Delhi or Kolkata. Does it mean, my lord, that we have to transfer the matter to Kolkata or Delhi? That is, my lord, the issue here is that, my lord, fact in issue here is itself is that he's a resident of India. That has to be proved. Without proving that, how can we accept that he's a resident of Dhuburi, or he's a resident of permanent resident of Kolkata, or he's a permanent resident of Kamrup, my lord? So before proving that, my lord, we cannot allow the matter to be transferred to some place where they are, my lord, preferring. What is the difficulty in proving their case in Jorhat, or what is the difficulty in proving their case in, my lord, Guwahati? Why they prefer some in that particular place? It is their duty, my lord. Section 9 of the, my lord, Act, Citizenship, the Foreigners Act has provided. Once, my lord, it is doubted his citizenship, it is their burden, their duty to prove that he's a permanent resident of this place or that place. Without proving that, how can we accept it, my lord? That means we are accepting that he's a citizen of India before the trial. Check. And this issues, my lord, this issue, my lord, has clearly been discussed in this case also. A court of a tribunal does not, if the jurisdiction fact does not exist, a court, tribunal, or authority cannot act. A court or a tribunal cannot wrongly assume existence of jurisdiction fact and proceed to decide a matter. It was held that the underlying principle is that by erroneous assuming existence of a jurisdiction fact, a subordinate court or an inferior tribunal cannot confer upon itself jurisdiction which it otherwise does not possess. The Supreme Court held that the existence of jurisdiction fact in Chinpu non on condition precedent for the existence of power by a court of limited jurisdiction. In the above context, it can be seen that in the case of Foreigners Tribunal, the jurisdiction fact is reference made by the concerned jurisdiction registering authority seeking opinion. The question therefore is, when the Foreigners Tribunal is given to decide a reference received from the registering authority of that district or part thereof, can another tribunal of a different district, not ordinarily having the jurisdiction to such a reference, emanating from the other district, assume jurisdiction to decide the reference, and whether the High Court, in exercise of power conferred under 226 of the Constitution of India, can confer such jurisdiction to the Foreigners Tribunal to decide a transfer reference? My lord, there is in the Foreigners Act 1946, neither in the Rule 1964, there is no provision of transfer as such. So we are, my lord, we are here, my lord, under 226 certiorari jurisdiction. The certiorari jurisdiction, the function of the certiorari jurisdiction to examine if there is error apparent on the record, face of the record, or error apparent in the, my lord, opinion passed by the tribunal. There is no opinion has yet come, my lord. So under 226, my lord, jurisdiction, certiorari jurisdiction, can we transfer the matter from one place to another? The certiorari jurisdiction, it is, my lord, it has been, it is in numbers of judgment, it is clearly, my lord, clear. Even in this, my lord, the Muslim Mandal, which is relied by everyone in this, my lord, only for this purpose. Muslim Mandal has clearly says, my lord, the High Court in these cases, under Foreigners Tribunal cases, High Court has the jurisdiction only the 220, my lord, certiorari jurisdiction under 226, while, my lord, deciding the matters of Foreigners Tribunal. It is in the, my lord, the para 9, it is in the 113 of the, my lord, para 112 and 113 of the, my lord, the, my lord, Muslim Mandal case. So the jurisdiction, our jurisdiction is only to look whether there is an error apparent in the opinion of the tribunal, my lord. So it is discussed here. It is therefore it is said, my lord, can confer under such jurisdiction of the Foreigners Tribunal to decide the transfer reference answer to the first part would not require any deeper consideration inasmuch as power exercised by foreigners tribunals are especially laid down on under para 4 of the 1964 order. The foreigners tribunal are conferred with the power of civil court while trying a suit under the Code of Civil Procedure 1908 and power of judicial magistrate first class under the Code of Criminal Procedure 1973 of summoning and forcing attendance of person, examining him or oath, requiring the discovery, production, and documents, issuing commission for existence of any witnesses, directing the proceeding to appear before it person, and issuing a warrant of arrest against the proceeding if he or she fails to appear before it. Apparently, if the foreigners tribunals are not vested with powers to entertain any plea to transfer of a proceeding before it to another tribunal. As regards entertaining a transfer proceeding, the same is also not permissible with jurisdictional facts related to different districts, and as such, fact is not found to exist in the referred transfer tribunal. As answer to the second part is indisputably the settled legal proposition that conferment of jurisdiction is a legislative function, and it can neither be conferred with the consent of the parties nor by Supreme Court, Superior Court, sorry. The court or the tribunal cannot derive jurisdiction apart from the statute. The finding of the court or tribunal become irrelevant, unenforceable, executable once the forum is found to have no jurisdiction. If a court or a tribunal lacks jurisdiction, acquiescence of parties should not be permitted or perpetrated or perpetuate defeating of the legislative animation. This view is echoed in the same in the case of this is the Jagat Mitra Sen Bhagat and others versus Director Health Service has been referred. This is 2013 10 SCC 136. Next, passing upon the provisions of section 24 of the Code of Civil Procedure 1908, this was argued by why this section 24 cannot be accepted. It deals with the power of transfer of suit, appeal or other proceeding pending before the High Court or the District Court when any court of subordinate to it for trial or disposal or withdrawal of any suit, appeal or other proceeding pending in any court subordinate to it for trial, dispose of the same. A reading of the section 24 makes it evident that the said provision would be applicable only in case of a suit or appeal or other proceeding pending before a court. The proceeding before foreigner tribunal is a quasi-judicial, as held by the full bench, the decision of the court in the state of Assam and others versus Muslim Mandal and others reported in 2013 1 GLT 809. The nature of proceeding is not akin to a civil suit or a criminal trial, as is commonly understood. The limited application of provisions of Code of Civil Procedure 1908 are powers as prescribed under 4 of the 1964. 1964 para 4, order 4 has clearly said in which cases the tribunal will have the jurisdiction of CPC and CRPC. Not in all cases, in all situations. Only for the purpose of calling the witnesses, summoning the witnesses, only for that, issuing the notice for that purpose. Para 4 of the 1964 order, as held by the vigilance of this court, case of in Safia Khatun versus Union of India and others reported in so. The opinion rendered by a foreigners tribunal is in the nature of quasi-judicial order, as held by the Supreme Court of India in its order dated so passed in Abdul Quddus versus so. The foreigners tribunal rendering such The foreigners tribunal rendering such opinion on reference made by the jurisdictional superintendent of police is certainly not a court. This is clear, my lord. It is we should exclude. This is admitted fact. The foreigners tribunals are not court, my lord. These are some quasi-judicial authorities, my lord. They are not court. It is admitted position. The provisions of the principles governing section 24 of the Code of Civil Procedure 1908 could not be tracked in respect of the proceeding before the foreigners tribunal. This has clearly asserted. In this connection, it would be opposite to notice that status of the post of members presiding over foreigners tribunal. On the question as to whether such members of judicial are judicial members, member is a judicial officer or subordinate of a subordinate court within the meaning of Article 235 of the Constitution of India. Single bench of this court exhaustively dealt with the issue in so and so. Well, here it is clearly, my lord, this was a case, my lord, where some of the, my lord, the members who have been terminated, my lord, they have silenced before this honorable court termination. There it is said that this is not they are not subordinate to this order. My lord, they are not court or they are not judicial officer of this court. As your lordship has seen, last occasion matter was listed before this honorable court. Your lordship has sent back the matter to the single bench. That the same manner. Here it is, my lord, clearly said, Article 236 of the Constitution defines judicial officers to mean a service consisting exclusively or persons intended to fill up the post of district judge and other civil judicial posts inferior to the post of district judge. In Sri Kumar Padma Prasad, the Supreme Court had observed that the expression judicial office in generic sense may include wide variety of office which are connected with the administration of justice in one way or the other. In the context of Article 2172A, the Supreme Court held that the expression of judicial office means a judicial office which belongs to the judicial service as defined under the Article 236B of the Constitution of India. The same analogy will have to be applied in respect of the interpretation of Article 234 of the Constitution of India. The post of member of FT is not a post under the Judicial Service Rules 2003, and therefore the submission of Mr. Bhattacharya that High Court has control as understood in terms of the Article 235 of the Constitution of India over the members of FTs is not tenable. So they are not judicial officers, neither they are courtmen. It is clear. Taking it further, it is seen that the provision under para 3A clause 3 of the 1964 order provides that foreigners tribunal shall have the powers to regulate its own procedure for disposal of the cases expeditiously in time-bound manner, and para 4 thereof prescribe the limited powers of the foreigners tribunal vis-a-vis a civil court. The special enactment under which the tribunals are created do not extend the procedure prescribed under the Code of Civil Procedure to proceedings before the tribunal. As in the case of foreigners tribunal, it is conferred with the power to show its own procedure, which is an attribute distinguishing the tribunal from the civil court. Again, a civil court cannot make departure from the procedure prescribed under the Code of Civil Procedure, while a tribunal can regulate its own procedure for disposal of the cases expeditiously in a time-bound manner. As seen from the para 4 of 1964 order, the provisions of Code of Civil Procedure 1908 is applicable only for limited purpose like summoning and enforcing the attendance of any person and examining him or her in oath, requiring discovery and production of any document, issuing commissions for examination of the witnesses, directing the proceedings to appear before it in person, and issuing a warrant of arrest against the person if he or she fails to appear before it. This by itself makes it evident that the intention of the legislature has been to liberate the foreigners tribunal from the constraints of procedure prescribed under the Code of Civil Procedure 1908. It can be deemed to be a civil court only for the limited purpose and the limited extent for the provision of 1964 order stipulates. Therefore, on the premises above, there can be no difference of view that foreigners tribunal presided over by member who is not a judicial officer of subordinate courts within the meaning of 235 of the Constitution of India, nor hold a post under the Assam Judicial Service Rules 2003, but holds a civil post, and which renders opinion in the nature of quasi-judicial order by discharging quasi-judicial function by regulating its own procedure within the limits of power of civil court. Vested it is under para 4 of the 1964 order. is not a court so much as to attract the provision of section 24 of the Code of Civil Procedure 1908. So it is clearly laid down that it is not a court, so section 24 will not attract. Section 24 will be CPC. We may now turn to the submission made on behalf of the petitioner on binding nature of judgment rendered by Supreme Court, which is placed in context of the dated so and so, arising out of so and so, the minor of Union of India, that case which they have referred. The said case before the Supreme Court arose out of the final judgment of this order dated passed on so and so, passed by the court, this court in WPC number so and so. In respect, it is reported in 2018 was GLT that was silenced. In the case of minor talk before the court, prayer was met for transfer of the reference case pending before the Foreigners Tribunal to Kamrup M at Guwahati to any Foreigners Tribunal at Karimganj. Basic ground urged was that petitioners herein being a resident of him under the Nilam Bazar Police Station, District Karimganj, it would be inconvenient for him to appear before the Foreigners Tribunal Guwahati for adducing evidence. Relying on the decision of the Supreme Court in Anita Kuswa versus Puspa Sadan, reported on 2016 SCC 509. It was contended that for the ends of justice, this court can always issue direction to transfer reference from tribunal to another tribunal. The operative part of the judgment passed by the court while ensuring the said petition may usefully reproduced herein under. This court has held in a number of cases that provisions of principles governing under section 24 of the Code of Civil Procedure 1908 would not be attached to the proceeding before a Foreigners Tribunal, which is governed by the provisions of Foreigners Act 1946 and the Foreigners Tribunal Order 1964 as amended. This court has also held that situations of residence of the proceeding or the inconvenience of a proceeding would be no ground for transfer of a reference from one Foreigners Tribunal to another Foreigners Tribunal. A proceeding before a tribunal is sui generis. It is neither a civil suit, as is commonly understood, not it is a criminal trial. There is no adjudication of lease between two litigants in an adversarial manner. The state, so the superintendent of police, make a reference to the concerned Foreigners Tribunal, seeking its opinion whether the proceeding is a foreigner or not. And a foreigner, if foreigner, to which system? Reverting to section 24 of the Code of Civil Procedure 1908, we find that the said provision deals with the transfer of suit, appeal or other proceeding pending before the High Court or the District Court to any court subordinate to it for trial or disposal, or withdraw any suit, appeal or other proceeding pending in any court subordinate to it and try to dispose of the same. Therefore, it is evident that provisions of section 24 of the Code of Civil Procedure would be attracted only in case of the suit or appeal or proceedings pending before a court. It is the settled position the tribunal is not a court. A foreigner tribunal assigned the task of rendering an opinion on a reference made by the superintendent of police certainly not a court. Is certainly not a court. In so far the case of Anita Kuswa is concerned, the issue before the Supreme Court was whether the Supreme Court had the power to transfer a civil or criminal case pending in any court in the state of Jammu and Kashmir to court outside the state and vis-a-vis. It may be mentioned that under section 1(3) of the Code of Civil Procedure 1908, it is clearly stated that the Code of Civil Procedure extends to whole of India except the state of Jammu and Kashmir and the state of Nagaland and tribal areas. Likewise, under section 1(2) of the Code of Criminal Procedure 1973, it is mentioned that the provisions of criminal procedure code would extend to the whole of India except to the state of Jammu and Kashmir. It is the context that a reference was made to the Constitution bench of the Supreme Court to examine the above issue. Referring to the expensive meaning given in Article 21 of the Constitution of India as well as right places justice under 39D of the Constitution of India, Supreme Court held that provision under Article 32, 136, and 142 of the Constitution are wide enough to empower the Supreme Court to direct the transfer of a civil and criminal case from state of Jammu and Kashmir to outside the state of Jammu and Kashmir in appropriate situations, notwithstanding the fact that civil procedure court and criminal procedure court do not extend to the state of Jammu and Kashmir. This was the precise issue before the Supreme Court in Anita Khuswa. Endeavor of learned counsel for the petitioner to apply the said decision in case of an opinion by a foreigner's tribunal, in our considered view, is far-fetched and doesn't stand to reason. Consequently, we are not inclined to entertain this writ petition, and writ petition accordingly dismissed. And that was challenged before the apex court, my lord. The apex court, which they are relying now. The aforesaid order code being so and so, as said in SLP number so and so, was disposed of passing the order following order. The order is there, my lord. Leave granted. Having gone through the pleadings, in particular, the counter affidavit filed by the state of Assam. It is not the pleadings of the petitioners. In particular, counter affidavit filed by the state of Assam, which they have not brought into the record. We think it fit on the facts of this case to transfer the pending proceeding before the Foreigners Tribunal number 2 at Hadarpur, Guwahati to the Foreigners Tribunal, Korimbe.
This counter is not on record.
It's not on record.
But we thought that it is filed, that pleading of the Supreme Court, counter file,
We have filed, madam.
you filed.
We have filed the
Counter by the
petition of the petitioner before the.
They have filed the petition of the petitioner, but not the counter of the.
You have not filed a
They have to
counter.
file counter, madam. They have not filed.
No, in that SLP, in the SLP Moinul Haq,
Yes, madam.
the counter filed by the state government is part of the record.
My lord, that part, my lord, we have only filed our petition of the Manil Haq.
Oh, but then what do we know? We don't know what was stated by the state
Well,
before the tribunal, before the Supreme Court.
That part is not with us, my lord. They are
Why not
they
with
can do
us?
it, my lord.
Huh?
They can file it, my lord. Their counter.
No, my lord, it is their case, they are placing.
Hmm?
Their case, they are placing, and they are filing part of the petition, my lord, part of the record, but not at the part on the basis of which the judgment.
Why
the
couldn't you
order was-
file the counter affidavit of the state also, Assam? That will give a clear picture. See, having gone through the pleading, in particular the counter affidavit filed by the state of Assam,
Yes, ma'am.
we think it fit in the fact case transfer. So that was based primarily on the affidavit filed by the state government in that Moinul Haq. You could file a copy of the petition Moinul Haq, but you could not file a copy of that affidavit.
My lord, that we could not collect, my lord.
What collect? We don't know, then how can we decide on the basis of incomplete pleadings?
Now, my lord, on behalf of the petitioner, it is stated that the order passed by the Supreme Court in minor talk creates a binding precedent, which should squarely be applicable in cases in hand.
If you don't file, then we will not be able to help you. Because we don't know what was provided in the counter affidavit. So we cannot presume things. Yes, please proceed.
Reliance is placed on behalf of the petitioner, it is stated that order passed by the Supreme Court in minor talk creates a binding precedent, which should squarely be applicable in case in hand. Reliance is placed in South Central Railway Employee Cooperative Credit Society Employee Union versus so and so, reported on so and so, wherein the Supreme Court in the facts of the case held that it was not open to the High Court to hold that the judgment delivered by the Supreme Court in South Central Railway Employee versus so and so was far inferior. In this context, the Supreme Court observed that when a higher court has rendered a particular decision the said decision must be followed by a subordinate court or lower court unless it is distinguished or overruled or set aside. Further, by not following the law laid down by the Supreme Court, the High Court or the subordinate court would be violating the provision of Article 141 of the Constitution of India. Reliance is also placed in case of this 2004-12 SCC 645 to say that it is well settled that the judgments of the Supreme Court are binding on all the authorities under Article 142 of the Constitution, and it is not open to any authority to ignore the binding judgment of this court. There can never be a dispute with regard to the submissions made on behalf of the petitioner based on the judgments rendered in South Central Railway and Paltina Sugar Mills. The question is whether the order of Supreme Court dated 29/01/2019 in Moinul Haq operate as a binding precedent as contemplated by Article 141 of the Constitution of India on the cases in hand, or is it an order passed in exercise power under Article 142 of the Constitution of India on the facts pertaining before it? To answer the question, we may refer the Director of Settlements AP and others versus Mr. Eparo and another reported in 2002 4 SCC 638. On the applicability of Article 141 of the Constitutional Supreme Court, the Supreme Court held that the said provision is in the Constitution unequivocally indicates that law declared by the Supreme Court shall binding on all the courts within the territory of India. However, the statements of the court on matters other than like facts may have to be binding courts as the facts of two cases may not be similar. What is binding is the ratio of the decision and not any finding of the fact. To determine whether a decision has decided a law, it cannot be said to be a law when a point is disposed of an concession. In the said case, the Supreme Court referred to the case of State of UP versus so-and-so and Amit Das versus Bihar reported in so-and-so, which held that a decision which is not expressed and is not founded on reasons, nor is proceeded on consideration of issue, cannot be deemed to be a law declared to have been binding effect as it contemplates by Article 141. The powers of the Supreme Court of India under 142 of the Constitution of India, which is exclusive to it and not available to the High Court under its plenary jurisdiction. As power jurisdiction is a power that gives preference to equity over law. It is justice-oriented approach as against the strict rigorous of the law. The principle and power of Article 142 has been expounded with great clarity in the case of Indian Bank versus ABS, so-and-so, reported on so-and-so, Ram Prakash Singh versus State of Bihar, reported on so-and-so, and the State of UP versus Niras Awasthi, reported on so-and-so. The Supreme Court held that direction issued under Article 142 do not constitute a binding precedent, unlike Article 142 of the Constitution of India. Further, the direction under 142 is issued to do proper justice, and the exercise of such power cannot be considered as law laid down by the Supreme Court under Article 141. To take a leave of this case in the state of Punjab versus so-and-so, the Supreme Court held that the directions of the court under Article 142 of the Constitution, while molding the relief that relax the application of law or exempt the case in hand from rigor of the law in view of the peculiar facts and circumstances, do not comprise the ratio decidenda, and therefore lose its basic premise of making it a binding precedent. This court on the Cui Vive has expanded the origins of Article 142 of the Constitution by keeping it outside the purview of Article 142 of the Constitution, and by declaring the direction of the court that since its complexion with the peculiarity in the facts and circumstances of the case. My lord, it is the exact case, my lord, where the order of the apex court has clearly, my lord, nowhere mentioned why only, my lord, there is no reasoning is only to give particular relief to that particular person. They have molded the, my lord, they have exercised their right, particularly on the basis of the, my lord, the pleadings of the, my lord, government. So this is not, there is no ratio, my lord, laid down here. So this is not binding on, my lord, any other court or even judicial court. So no ratio, my lord. Only line is that if we go, my lord, the para 2 is the order. Para 2 has clearly said, having gone through the pleadings, in particular the counter affidavit filed by the state of Assam, we think it fit on the facts of this case, my lord, to transfer the pending proceedings before the foreigners tribunal so and so to so and so. That mustn't. It is fully on the discretion under 142, my lord. The Honorable Apex Court has sent a matter. This has been distinguished clearly by this Honorable Court in this case. The counsel for the petitioner laid much emphasis in the case of Anita Kuswa to say that access to justice being guaranteed under Article 14 and 21 of the Constitution of India, the physical and financial inconveniences of parties witnessed in the appearing before the foreigners tribunal located away from their home, town, or relevant considerations for seeking transfer of the case from tribunal where the case is pending to the tribunal located in their home district. Submission is also made that this court, in exercise of power under 226 of the Constitution of India, is competent to direct such transfer. In order to reach a conclusion on the submission method, we would pertinent to understand the context in which the decision of Anita Kuswa was rendered. Before going, my lord, there are lots, my lord, and substance. The only substance is that, my lord, this honorable court has rejected. They are on the basis of this, my lord, Moinul Haq case passed by the Apex Court. The transfer cannot be accepted. And this is, my lord, settled proposition. This is settled, my lord. This is settled proposition. Now, my lord, my lord, I'll submit. I'll argue other parts, my lord. The merit. Yes. It is only, my lord. Now, my conclusion is that this is a settled proposition of law, my lord. Now, if your lordship want to hear it on merit again, then, my lord, this will be unsettling the settled proposition. So my submission is that, my lord, my lord, I'm leaving apart the other side. My lord, only as this has been settled clearly. So on the basis of itself, this settled proposition may not be disturbed. And if, my lord, your lordships other way, my lord, want to hear it, then my submission will be, my lord, the view, contradictory view, if your lordship wants that it may be hard as by our opinion. It may be understand to the larger bench for that purpose to consider. Because, you know, the merit, then, my lord, I can submit on merit whether details in details. Only at this is this, my lord. Please. Well, for that purpose, just I'm relying on judgment of this ex-court, man. I'm sorry, my lord, I could not provide proof of this. Here, 2000. Two issues are here in 2010-13 SCC. This is 336. But para 16, 17, and 18. This is 2010-13 SCC, my lord, 336. Santilal Gupta and others versus state of the modern cooperative groups. My lord, para 16, 17, and 18. May I read the 16? Para 16 says, be that as it may, the High Court has referred to its division bench judgment in so and so, wherein the same provision had been considered and it had categorically been held that deeming approval was not legally permissible. In view of the above, it was neither desirable nor permissible by the coordinate bench to disapprove the earlier judgment and take view contrary to it. Well, the next line is not necessary. Then para 17. A coordinate bench cannot comment upon the discretion exercise or judgment rendered by another coordinate bench of the same court. The rule of precedent is binding for the reason that there is a desire to secure uniformity and certainty in law. Thus, in judicial administration, precedents which enunciated the rules of law from the foundation of administration of justice under our system. Therefore, it has always been insisted that the decision of the coordinate bench must be followed. Some citations have been relied on. Then para 18, my lord. In Rajasthan Public Service Commission versus so-and-so, the court held that a bench must follow the decision of a coordinate bench and take the same view as has been taken earlier. The earlier decision of the coordinate bench is binding upon any later coordinate bench deciding the same or similar issues. If the later bench wants to take a different view, then that taken by the earlier bench, the proper course is for it to refer the matter to a larger bench. So my submission is that the matter has been settled by this member court, coordinate bench. So this is final. They have not preferred any appeal against that. They have not preferred any appeal against that, my lord. Now, my lord, arguing again and again on the same issue. This will, my lord, settle the entire. And as this judgment is before your lordship, I want to rely, just read out para 28. Para 28, my lord. This is how certiorari, because my lord, these Muslim Mandal, my lord, that has been accepted as my lord, the guideline for the foreigners tribunal now, my lord. So Muslim Mandal has clearly said this court has power on my lord, of certiorari for the purpose of my lord, foreigners tribunal issue. No other power has been given, my lord. My lord, Muslim Mandal, just I'm reading out that portion, my lord. It is clearly said only 220, my lord, certiorari under 226. My lord, I'm just reading out, my lord, because it may not be there. Para 112, my lord, of the Muslim Mandal. This is Muslim Mandal 2, my lord, 2013 1GLD 809. Just I'm reading out for the purpose, my lord. Article 226 of the Constitution confers on the High Court power to issue appropriate writ to any person or authority within its territorial jurisdiction. The tribunal constituted under the 1946 Act, read with 1964 order, as noticed above, is required to discharge the quasi-judicial function. This also has clearly quasi-judicial function. Para 112. Para 112. Article 226 of the Constitution confers on the High Court power to issue appropriate writ to any person or authority within its territorial jurisdiction. The tribunal constituted under 1946 Act, read with 1964 order, as noticed above, is required to discharge the quasi-judicial function. Next line. The High Court, therefore, has the power under Article 226 Constitution to issue writ of certiorari, quashing the decision of the tribunal in an appropriate case. My lord, there is no other, my lord, provision, even in the, my lord, where my lord, under which authority this court will function, or this what order will pass by this honorable court against any decision of the tribunal. This is the only line. This line has clearly says, my lord, the High Court therefore has the power under Article 226 of Constitution of India, Constitution, issue writ of certiorari, quashing the decision of the tribunal in appropriate case. This must. Now it is said, the scope of interference with the tribunal order in exercise of the jurisdiction under Article 226, however, is limited. The writ of certiorari can be issued for correction of errors of jurisdiction, and when the inferior court or the tribunal acts without jurisdiction or in exercise of it, or fails exercise of it, or if such court or tribunal act illegally in exercise of the subordinate jurisdiction, or when it decides without giving an opportunity to the parties to be heard, or violates the principle of natural justice. The certiorari jurisdiction of the writ court being supervisory, not appellate jurisdiction. The court cannot review the findings of the facts raised by the inferior court or tribunal. There is, however, an exception to the said general provision, as much as the writ of certiorari can be issued, and for the decision of the tribunal, and the tribunal on a finding fact can be interfered with if a recording of such finding that the tribunal has acted on evidence which is legally admissible, or has refused to admit admissible evidence, or if the finding is not supported by any evidence at all, because in such cases such error would amount to error of law apparent on the face of the record. The other errors, the other errors of facts, however grave it may be, the other errors of fact, however grave it may be, cannot be corrected by this writ court. So, my lord, as we are exercising under my lord certiorari jurisdiction of 226, I am not just for the purpose I am submitting, my lord. Otherwise, first of all, I am submitting that, my lord, as it is a settled proposition. So that may not be disturbed. Even though, my lord, we exercise, we have that power under 226 certiorari jurisdiction to transfer the matter from one place to another. Because they have not filed a transfer petition under CPC. They have not filed any transfer petition under CPC. They have filed a writ petition 226 under. And under foreigner against the foreigners tribunal, only power under of this honorable court is certiorari jurisdiction. I have numbers of other arguments also in this issue, my lord. But at this moment, my lord, for the If your lordship decides on that point, my lord, first of all, your lordship overcome that, then other parts, other issues will argue.
Yes, sir. Anything you would like to say?
My lord, here in this case, my lord, my friend has said, the sorcery jurisdiction, my lord. Sorcery jurisdiction, my lord, here, that jurisdiction, question of that jurisdiction does not arise. We are not, challenging any decision of the tribunal. My lord, here, my lord, the learned counsel from the other side has basically relied upon the judgment of the Shariful Islam and Monil Haq case, my lord. And both those judgment, my lord, the past, according that the tribunal is not a court. The proceeding before the tribunal is a lease, my lord. My lord, and the CPC not applicable. But CPC, my lord, applicable, my lord, rule 4 says, my lord, the application of CPC. Maybe, my lord, limited jurisdiction. But the CPC is not totally excluded. The spirit of CPC is to be applied here also, my lord. And therefore, my lord, the Supreme Court in the case of Muslim Mandal case has said that the tribunal is a quasi-judicial authority. Its decision has a civil consequence. And my lord, CPC, my lord, is applicable. Section 11 is applicable. When Section 11 is applicable, my lord, why not the other, my lord, in the my lord, for the ends of justice, for the protection of suffering people, my lord. So, my lord, Rule 24 is also Section 24 of the CPC is also applicable. My lord, I want to rely on, I just make a my lord, reference, my lord, on the judgment on the minor law passed by this honorable court in a writ petition, my lord. Here, my lord, paragraph 12. It was observed, a proceeding before a foreigner's tribunal is a sui generis. It is neither a civil suit as a commonly understood, nor it is a criminal trial. There is no adjudication of lease between two litigants in the adversarial manner. Well, these points have been overruled in the Abdul Quddus case. Meaningless. I want to refer the Abdul Quddus case, my lord. Here, my lord. Paragraph 23, my lord. There in the middle portion of the paragraph 23, my lord, there has been an observation The opinion by the Furnace Tribunal is a quasi-judicial order and not an administrative order. Paragraph 23. The expression quasi-judicial order means a verdict in writing which determines and decides the contesting issues and questioned by forum other than a court. The determination has civil consequence. The explaining the meaning of the quasi-judicial body in Indian National Congress I versus Institute of Social Welfare. It was held that when any body of persons has a legal authority to determine questions affecting the rights of subject and a duty to act judicially, such body of persons constitute a quasi-judicial body and decision given by them is a quasi-judicial decision. It would also be a quasi-judicial order. If the statute power empowers an authority to decide the lease between the two contesting parties, but also when the decision prejudicially affect the subject as against the authority. Well, this line is very important, my lord. Well, it may not be adversarial by the two party, but if decision is against the government and the other party is affected, that should be looked into, my lord. Provided that the authority is required by statute to act judicially. Further, what differentiates an administrative act from the quasi-judicial act is that a quasi-judicial body is required to make an inquiry before arriving at conclusion. In addition, the administrative authority is the one which is dictated by policy, expediency, and whereas quasi-judicial authority is required to act according to the rules. So, my lord, the contention raised by the learned friends in the light of the Shariful Islam case, my lord, and the judgment of the Moinul Haq case is ruled out. This CPC is applicable here also. Maybe limited purpose, like the Supreme Court also set aside the decision of this court in the Shahjahan Ali and Amina Khatun on the point of writ judicata. So, my lord, this point is also applicable. And my lord, my case is, my lord, the proceeding in his statement before the inquiry officer, he stated that he is a citizen, he is a ordinary resident of Kukrazar. He has documents. He wants to produce, sometimes required, but that was not given. His defense at the investigation stage was denied. So that amounts to violation of Article 21, my lord. And when the investigation is been referred illegally, whether that can be a reference? The reference itself is an invalid, my lord.
That issue I have not come yet. I'll come to that. That is not only transfer issue. Because I have not argued.
My lord, here, yes, my lord. I'm in support of my contention. I am to make submission. I have not raised any word when you are making submission. So let me make submission, my lord. So, my lord, my question is that the justice is to be availed by the litigants, and his claim, his right under Article 21 at the investigation stage has been blocked, has been denied by referring the case illegally without fair investigation. My lord, that is one aspect, my lord. And here, my lord, the contention of the petitioner is that his all documents to support his claim are lying with the district magistrate Kukrazar. The authority made the reference without verifying those documents, without referring the case to the appropriate authority who can make an inquiry fairly. They have not been referred, and they illegally referred the case to the tribunal. So, the Rule 22, my lord, has been kept out of mind that the reference, reference shall be made in looking into the documents where he is an ordinary resident. That has not been done. Then, my lord, so, my lord, there has been a wrong interpretation of the reference also. Since reference is to be made, is a valid, should be valid reference. That reference is, the laws does not say what is the definition of a valid reference. That has not been said, but Rule 22 said the indication has been given. What should be the valid reference?
Anyway, that we have argued.
My lord, yes, my lord. My lord, I want to make another judgment, my lord. Here, my lord, in the light of the article, my lord, 39A, my lord, the Supreme Court has decided, my lord, the Unita Kushwa case, my lord, that I want to rely, my lord. Paragraph 29, then 30.1 and 42, 43, 44 and 45, my lord. Article 39A, my lord. State shall secure the operation of legal system to promote the justice, my lord. My lord, if the inquiry is made this way and the trial is conducted in that way, my lord, without giving out opportunity of fair trial, then definitely it is a violation of Article 39A, my lord. And Supreme Court, my lord, keeping all these, my lord, the Nita Kushwaha case, my lord, the power has been exercised to transfer case, my lord.
Para you are related.
Para, my lord, para 29, my lord. Para 29, my lord, 30 number out of judgment. I am no expert to be, my lord. I have given the copies, my lord. I have given mark, my lord. Mark, I have given mark, my lord. Judgment আছে, he judgment will be hanging. এই কিতাব এটা আছে, Nita Kushwaha case. What does judgment আছে? Itu hanging. 2016 or judgment.
Yes, yes.
My lord, with all this, my lord, I want to
Okay.
my lord.
Anyone else you want to say something?
Lordship, the question arises whether the tribunal or the quasi-judicial body is a court or not. In CPC, there is no definition of court. And in the General Clause Act, there is also not any definition that has been given. But in the Legal Service Authority Act 1987, there is a definition of court, your lordship.
You're Mr.
Piram,
Piram.
Legal Service Authorities Act 1987. Section 2. Section 2(1) triple A. Section 2(1) triple A. Definition. In this case, unless the context otherwise required, triple A court means a civil, criminal, or revenue court and includes any tribunal or any other authority constituted under any law for the time being in force to exercise judicial or quasi-judicial functions. From this definition, the tribunal, foreign tribunal has come under the definition of court, your lordship. Lordship has already, it is a settled provision, settled law that the tribunal is functioning as quasi-judicial. That means it is also being called as a court. Section CPC, your lordship. Then come to CPC, your lordship. Section 3, your lordship. Subordinate to courts. Section 3, subordinate to courts. For the purposes of this code, the district court is subordinate to the high court, and every civil court of a grade inferior to that of a district court, and every court of small causes is subordinate to the high court and district court, your lordship. The foreign tribunal has come under Guwahati High Court as per section, under the High Court as per section 3 of CPC. Lordship, then come, lordship, please come to page section 24, your lordship. General power of transfer and withdrawal. 1A. 24(1). On the application of any of the parties and after notice to the parties and after hearing such of them as desired to be heard or of its own motion without such notice, the High Court or the District Court may at any stage transfer any suit, appeal, or other proceeding pending before it for trial or disposal to any court subordinate to it and competent to try or dispose of the same or. That means so the tribunal is a court as per the definition provided in Legal Service Authorities Act, your lordship. The section 24 is applicable, your lordship. Now, your lordship, the petitioners before your lordship transfer the proceeding, not quashing the proceeding, not quashing the reference. The limited prayer is to transfer the proceeding from the local jurisdiction. Lordship, my friend of other side will know that I have gone through one, I have noticed one reference in some of the order of foreign tribunal. Government order. I don't have this notice, your lordship. The friend will, I think the friend will have. It is Home and Political Department. Dr. Masham has issued this notice. This in 2015. By this notice, the jurisdiction of the tribunal are divided on the basis of police station, your lordship. They can provide, your lordship. I don't have this, but I have found in several judgment several order of Tribunal, Your Lordship. It is PLB 160/2013/ Part 1/95, dated 10/8/2015, issued by Home and Political P. Goptam Assam. By this notification, the jurisdiction of a tribunal has been divided and decided on the basis of police station. Rashid, my little understanding of law is that when the Honorable Supreme Court has allowed the petition of Mainul Haq by setting aside the decision of our coordinate bench of this court. The said order of our coordinate bench, my understanding is, Lordship, that it does not hold any field. But it may not be the binding proceeding. It may not be binding proceeding as my friend has argued, but it gives some light to decide the fate of the petitioner. Since already the Honorable Supreme Court has allowed the transfer of Mainul Haq case, the Lordship, it gives us that some lights to decide as to whether this Honorable Court has power to transfer or not. And if transfer, the time it transfer, justice should be prevailed, Your Lordship. First and foremost is the justice should not be suffered, Your Lordship. In earlier occasion, I have referred one Supreme Court judgment, the balance of convenience and inconvenience, Your Lordship. The fact in the tribunal, Fairness Tribunal, state never examined any witnesses, never adduced any evidence, and this fact has been recorded in Lordship judgment in Hyder Ali case, Lordship. In Hyder Ali case, para 27, Your Lordship. Fourth paragraph 4 of para 27, not mine. May I read, Your Lordship? From the record, it is also seen that after issuing summons to the proceeding or before issuing summons to the proceeding, the tribunal does not examine any of the persons who had made the reference or who had conducted the investigation against the proceeding to hold that the proceeding is a foreigner. Lordship, in the same judgment, Your Lordship, paragraph 38, Your Lordship. I am submitting on the principle of balance of convenience and inconvenience, Your Lordship. Paragraph 30. In the proceeding before the Fairness Tribunal, no fact nor any charge is required to be proved beyond reasonable doubt by the state. The state merely makes an allegation based on certain investigation that the proceeding is a foreigner. The practice flowed so far as can be seen from the record is that nothing is furnished to the proceeding by the state or the tribunal except for the summons notice stating that the proceeding is a foreigner who entered Assam India during a particular period of time. In fact, the onus of proving that the proceeding is not a foreigner is placed on him in terms of Section 9 of the Foreigners Act 1946. Further, the tribunal does not direct the proceeding to produce any document. It is for the proceeding to produce such evidences and documents in support of his claim that he is an Indian. The more credible evidences he produces, the better for him. Yet production of less evidences can't necessarily lead to rejection of the claim of the proceeding or drawing of any adverse interference. Your Lordship, if the proceeding has been transferred to Jorhat, transferred from Jorhat to the jurisdictional district at Morigao, whether the state will be prejudiced or not, Your Lordship. From the fact as recorded in this judgment, Your Lordship, as observed in this judgment, state will not be prejudiced. Only the records will travel from Jorhat to Morigao. Nor the referring authority, nor the inquiry officer will have to come to Morigao from Jorhat to adduce evidence against the proceeding, Your Lordship. It is only the proceeding who will adduce evidence, who will examine witnesses, maybe his or her parents, age-old parents, teacher, school teacher, Gaubura, circle officer, Lat Mondol.
Yes, next.
So, Lordship, if a citizen,
You see, you don't argue same thing again and again. What we have argued last time, you don't repeat that. It is not for repetition or you want to add something else, you say that.
Lordship, my
So
only
in response to Mr.
last
Patil.
submission, Your Lordship. Foreigners Tribunal Act is the main objective of Foreigners Tribunal Act is to find out the foreigners. At the same time, another objective is that the citizen, the original citizen should not be lost citizenship. So burden of proof, to discharge the burden of proof, the transfer of the proceeding from Jorhat to original place may be done since the Foreigners Tribunal is a court, and 226, Article 226 is
Okay.
under Article 226.
Yes. Anybody else?
That's all.
Anybody else? Okay. Mr. Landry. Judgment. Yes.
One thing, my lord, your lordship, as my learned senior friend has argued, my lord, the Abdul Quddus case is relied on. That Abdul Quddus case was also, my lord, taken note of by this honorable court while deciding this matter, my lord. And the only line it is clearly said, my learned senior friend also read out, my lord, that the tribunals, the opinion rendered by the foreigners tribunals is a nature of quasi-judicial nature. That has been there in the Abdul Quddus. That was taken.
Tribunal is a quasi-judicial body. That's why it is come under the definition of court, Your Lordship. But well, a Legal Service Authorities Act, 1987.
If my learned friend wants to argue on that, I have numbers of judgments that this does not put. I'm not on that, my lord. Only this.
देखो सबका नाम लिखो हाँ मिस्टर
My only submission, my lord. Apart from that, my lord, that argument or that, but in humanitarian grounds. To see the condition of the poor people, on that ground also, this court has the power to transfer a particular case from another district to other district.
On what basis humanitarian ground? I don't
Because
know.
his poor people, daily wages.
Is there any order? Is there any judgment? Are you relying on any judgment that because you are poor, therefore it can be transferred on humanitarian ground? Any decision?
There is no such decision, but
Okay. सबका नाम लिखो judgment is
Review petition as the last item, my lord, today as my lord unlisted because there is some urgency, my lord.
what agency?
My lord, the fact herein is that that my lord, the petitioner has been, my lord, petitioner is promoted to a post, my lord, and my lord, without any notice, my lord, he has been reverted to his original post, and my lord, the honorable court has, my lord, stayed at my lord, reversion order, my lord. Then the liberty has been granted. The department may, my lord, by issuance of notice, my lord, they can be reverted. But because there is no any clear direction for rejoining, that's why, my lord. But all other, my lord, similarly situated petitioner have, my lord, filed a review petition, my lord. And the honorable court
unlisted, unlisted.
but this the petition on basis of this review order, my lord, all the my lord, his colleagues has already been, my lord, promoted. He's going to retire, my lord, very soon, my lord, on 14th.
No. This on Wednesday it can be taken up.
My lord, on Wednesday, man. Wednesday, man.
My lord, item number 3 to 6, my lord. Ultimately, they are relying on the Bhanumati case, my lord, and
Yes.
Mr. Goswami case is fixed on Wednesday.
Yes.
So these cases may be fixed on Monday, my lord, next Monday.
Monday?
Yes, next Monday, my lord. Because in the meantime, on Wednesday, the Mr. Goswami case has been fixed. So ultimately, it depends on that case.
Okay, Monday. Okay. In the prayer of Mr. Hussain. Yes, next.
3 to 6, my public.
May it please, your lordship, with the concern of the other side, I beg to mention item number 7 to 11.
Yes.
I am being led by Mr. Yuki Nair in this case, your lordship, his health is not in a good health condition, so he has.
What happened? What happened? What happened?
Sound box is down, your lordship. He came today, but again his voice went down today, your lordship.
Right. Came today means where? What
To
happened?
the court but again his sounds vanished. Your lordship.
Okay.
For 2 weeks, your lordship.
2 weeks. Okay. On the prayer of Mr.
Arsina.
Arsina on behalf of UK Nair. Conducted on a conditional council, conditional council, matter stand adjourned for 2 weeks on account of health, on health ground. Yes. 7 to 11, huh? Yes.
Meet please, your lordship. Meet please, your lordship. With the consent of the other side, I beg to mention item number 16 of the daily list, your lordship.
16.
Yes, your lordship. Kindly
Yes.
this matter may be taken after 2 weeks.
About 2 weeks. You are 19,
My lord, what has happened, my lord, they had initially not taken steps for service of notice upon the respond number 2 to 4, my lord. Subsequently, they have taken, and today there is a large amount of report that service is complete. So anyway, my lord, we'll have to wait for some time.
On the prayer of Miss?
Yes, sure, my lord.
Yes, sir. 2 weeks.
Deeply applied.
Also, Mr. You're there, Mr. B. Sharma, huh?
For the respond number 1, my lord.
For respond. Okay.
May I please, lordship?
Yes.
Concern of the other side, I beg to mention item number 15.
Ah.
13.
Yes. On behalf of your, what is your name?
J. Gogoi.
J.
On behalf
Gogoi.
of BP Bora.
I am appearing for the petition.
Item
I am
number
appearing
13.
for the respondent.
Oh, I see. We are standing on the side of the, that's what we thought, huh? Okay. On prayer of Miss
J. Gogoi.
J. Gogoi, on behalf of
BP Bora.
BP Bora for the respondent, matter stand adjourned. Huh? How many days?
After 2 weeks.
We have also Mr.
S. Dekala.
S. Deka for the petitioner. Yes, next.
Like,
My Judicial Lordship. With the consent of the other side, I beg to mention item number 17 of today's list.
17.
Yes, Lordship. Lordship,
May
my,
I pray for it since he is in payment, my lord.
Oh,
For that.
oh, I see.
No objection. Father, may I pray for a date, my
Yeah,
lord? It may be on 21st November, my lord.
kindly, Lordship may kindly fix it on December, any date, up to the convenience of your Lordship. Any date on December.
It's a review petition, it's up to your lordship, my lord. It's a review petition, my lord.
21 of November?
21, it will not be possible, Lordship, because my senior won't be in the station. Lordship.
No, 15
We have
days,
some-
no, for
Yes, tomorrow is Saturday.
tomorrow is a
Starter ceremony.
Shraddha.
After 2 weeks.
So, yeah, so that what 21 is. after-
21, we have some outstation matters that is for Lordship.
What outstation?
Out
What
of
is
station
there?
days.
Huh?
My senior will be in Kolkata that time.
But then this matter is pending for so many years.
1985, my lord.
985, and you have not received that amount also.
No response from them.
21 will dispose it on 21.
Can it be on 25th, Lordship?
25th.
Yes.
No, because this, we don't sit on Monday or on Wednesday only.
Because Monday and Wednesday, my senior won't be in station. Lordship.
Sorry,
20.
huh? You make some arrangement. 23. Yes, next.
Apply.
23.
May I please your lordship? Lordship, I beg to mention item 18
Yes.
of the daily list. Lordship, due to some personal difficulty, my senior B. Chaudhary, he wouldn't be able to attend court today.
Have you informed the other side?
Yes, we have.
Yes, sorry.
Yeah.
This is regarding this money, means his salary is not paid, and the review was filed. But that may be fixed, I can accommodate him, no problem.
Okay. On the prayer of Ms.
A. Tarana, your lordship.
Tarana on behalf of Mr.
B. Chaudhary.
B. Chaudhary, let the matter be listed again on so and so. How also Mr. Huh? Mr.
I'm
MJ Barua. Yes.
3011 30.
30.
Obliged.
Daily list for admission, item 1.
What is this?
Item 1, my lord, Lordship had the matter once.
Huh.
So with regard to the pay scale of the library assistants of the Guwahati High Court
Yes.
and the judicial assistant of the Guwahati High Court.
But I attend for Mr. H.K. Das, my lord, standing counsel, Guwahati High Court. He is on legs in court number 1, my lord. He'll be here shortly.
We'll wait for some time. Let us. Yes. Next.
Item number 2.
What is this? Is it
May please,
19
it's
matter?
arbitration. Lordship, with instruction of petitioner, he is not willing to pursue the case, he want to withdraw the case. Lordship.
Okay. What is your name?
K. Islam.
Mr. K. Islam. Are you a Wakalanama?
Yes, Lordship, my name is there.
K. Islam, Lane Counsel for the petitioner submits that petitioner expressed desire not to pursue the matter. In view of the above
Yes.
submission made, the present petition stand closed. Closed. How also, Mr.
M. Moore for the record.
Also with liberty, fear, coming financial consequences, okay, you can.
However, liberty is granted in the event cause of to approach this court again if cause of action still survives.
Item number 12.
Hotik, what is this? Yes.
I'm appearing on behalf of Mr. B. Pathak, my lord.
Ah.
Some medical agency, my lord. He could not come to the court.
Lordship,
This matter may be taken
the
on.
matter issue is very much simple, Lordship. And just. for the
Correct,
sake
but then
of,
he says that he.
Yes, no issue, Lordship.
Then in that
For a
case,
short date,
Taken
on Friday,
31st, my lord.
in Friday, Lordship,
Friday, no, only Monday and Wednesday.
on Monday, Lordship.
Monday, next
Monday,
month.
Lordship.
Okay.
My
On the prayer of Mr.
B. Kumar,
B. Kumar, on behalf of Mr.
B. Pathak.
He parted the lease the matter again on Monday.
2111.
Keep there.
Item number 14.
Anybody for item number 14? D Deca, Bora, Huh?
Item 14.
Item 14, yes, yes.
Lordship. 14 and 15, we agreed to the arbitrator. They have proposed the name of Justice B.K. Sharma for both the cases. We said one is Justice B.K. Sharma would be okay, the other one would be any other arbitrator. Lordship. We have urgency because the bank guarantees they are trying to invoke, Lordship.
Mr.
D. Deka.
D. Dekalana counsel for the petitioner. Non appears for GMDA. In this case, they have agreed for whom?
They have proposed the name of Justice B.K. Sharma in both the cases.
In this particular case, which one you are agreeable?
I don't know the cases, Lordship. We have not chosen the case to be given to Justice B.K. Sharma. We said one case would be for Justice B.K. Sharma and the other one could be any other.
So this one B.K. Sharma or
Yes,
no?
Lordship, no problem.
Mr. Deka submits that he has been informed by his counterpart in GMD, the counterpart Mr. Bora, standing counsel GMDA, that they will be agreeable to the appointment of Mr. Honorable Mr. Justice B.K. Sharma, retired judge of the High Court, to act as arbitrator. And in view of the above submission made, the present petition closed by appointing Honorable Mr. Justice retired as a sole arbitrator to act to resolve the dispute between the parties. Full stop. Parties will appear accordingly. Honorable Mr. So be intimated of this subject to his consent.
Yes.
Consent. Full stop. Subject to consent. The party will appear for the for an honorable arbitrator. Huh? When will he appear? 2 weeks.
2 weeks, Lordship.
In 2 weeks. It is then disposed of. Then in this another one is
Similar parties, Lordship, but
item number
15, Lordship.
15. But you want somebody else.
Any other arbitrator.
Who is the other one who is now
Justice D. Viswas.
D. Viswas?
Yes,
Okay.
Lordship.
And Mr.
That he has not given consent to me. I'm just telling.
Okay. Deka. I'm Mr. D. Dekalana counsel also. We have been though Mr. S. Bora, Planner Steering Council, his counterpart has agreed to appointment of Honorable Mr. Justice B.K. Sharma, retired judge. However, it will be more appropriate, according to Mr. Deka, it will be more if somebody else, another arbitrator is appointed.
As these 2 cases.
Appointed in this particular case, in view of the above submission, full stop. Accordingly, though Mr. Bora is not present to this court, having considered the submission advance, this court view that Honorable Mr. Justice
D.
Viswas may be appointed to act as arbitrator to resolve the dispute between the parties subject to his consent. The petition is accordingly disposed of. Party will appear for Honorable so. Copy.
He is here.
D. Viswas, any problem?
One is D. Viswas.
In
B.K. Sharma.
B.K. Sharma, that one we have agreed. And this D. Viswas? Huh?
What to take to that consent, my lord.
That is, of course, is given.
If there are any conflict of interest.
Correct. We are subject to his consent. And in this case, D. Viswas, subject to his consent. Then in the Likho, and Mr. Swanso, who are also so earlier, petition then this one. Yes.
Item number 19.
Anybody? What is this? What is this? I have for what?
Just for paper publication, my lord.
Huh?
My lord, my senior is on his way, my lord.
No, but whether he has published the paper in the
Yes, lordship, we have taken steps, lordship.
You have taken steps. Okay. Who is for the other side? Nobody appearing, huh?
No.
You have taken step for service upon 1, 2, and 3.
Lordship.
Huh?
Lordship.
What is the newspaper? Where is it? Petitioner has filed application, have filed affidavit showing the steps to show the step being taken for service of notice upon respondent by way of publication in two widely circulated local newspapers, one in vernacular, one in English. One is vernacular, that is Okhomia Proceeding, and English, the Assam Tribune, dated 8/10/2022. Full stop. Accordingly, it will be deemed that notice has been served upon them. However, since it is by way of substitute services, we give another two more weeks for their appearance before this court. At least after 2 weeks. Next,
Item number 20.
what is this, Devendra Jain?
They took time for substitution of person number one.
Yes, my lord. But as per instruction, only petitioner is not interested to substitute.
Mr. K. Rahmanlal,
Yes, my lord.
counsel for the applicant, who submits that he has instructions. He has instruction. He has instruction that the applicant is not interested in
To substitute.
not interested in taking step for substitute service under the circumstances. This court no other option but to close the petition
Yes.
as on failure of the petition to take steps.
Substitution. Substitution person number one.
Huh?
Substitution, person number one died.
Okay, okay. Under circumstances, there is no, but to close this IA
Yes.
for substitution
Non.
of the respondent number one
One. Yes.
on his demise during the penalty.
Obliged.
IA is accordingly closed.
My lord.
Then what will happen to the man?
Nothing, my lord, because that is already dismissed.
Okay, okay,
Mainly.
okay. Then next,
Timing 1.
Obliged.
item number 1.
What I could advocate is Kedas.
Wait for, then let him come, then we'll wait, then next Monday. Today is Wednesday.
Today, Monday.
Monday.
Next Monday, 21st.
21st, huh? Is it okay? 21st?
List over.
Please tell Mr. Das.
Yes, my lord. Another thing, my lord, kindly. The state government finance department being represented by Rajiv Pujari. His name has not been shown. He is absent, my lord.
Okay. Oh, I see.
Cause list, his name may be shown.
Okay.
R. Pujari. For government.
List so by showing the name of Mr. R. Pujari, Learned Standing Counsel for
Revenue.
Revenue Department also.
Obliged.
Along with the standing counsel, Mr. S.K. Das.